Welcome to the Health Information Series. This is Dr. Gordon Wong. In this video, I'm going to talk about healthcare directives. Usually, when I talk about various diseases, the information is useful to everybody. However, healthcare directive is a slightly different topic. It involves both medical and legal concepts. The legal concepts I'm going to discuss in this video are based mainly in US and especially California laws, so if you're from another jurisdiction, you may want to consult with your local lawyer on whether the information is applicable to you or not. I believe most of the concepts are still relevant, but the detail on how to execute some of the documents may be different. Usually, I record my videos in Cantonese only, but this one is slightly different. A senior friend asked me to prepare two versions, one in Cantonese and one in English. The reason is that he thinks this information is very useful for a family to discuss and to plan. But in Canada, US and Australia, it's very often to have parents speak mainly Cantonese, but children speak mostly English. In order for the family to be on the same page to discuss the issue, he suggests that I record both an English version and a Cantonese version so that the family can view it first and then get together and discuss. If you want to see the Cantonese version of this video, click on the link above and it will take you to the Cantonese version. So what is a healthcare directive? A healthcare directive is a legal document that specifies how to take care of a patient when he or she can no longer make decisions for himself or herself. It is actually not one document, but a collection of several legal documents. We'll go into the details later. Healthcare directives have become an important part of medical practice in the Western world in the past several decades. It is based on the concept of patient autonomy, and there are two elements to the concept of autonomy. The first one is the patient's right to know. Patients have an absolute right to know their diagnosis, the treatment options, and the possible outcomes. When I was young, at least in Asia, it was fairly common for a child to tell the doctor, "Don't tell my father, he has cancer. I don't want him to worry." But right now, this is not acceptable. Unless the patient tells the doctor, "Don't tell me anything, just tell my kids." Otherwise, the doctor cannot hide anything from the patient. The second element of patient autonomy is the right to make one's own decision about care. A patient has an absolute right to decide what he or she wants in terms of treatment, even though the result may not be the most desirable one from others' perspective. There are several ethical reasons to respect patient autonomy. The first one is the right to pursue happiness. It is a fundamental right for everyone to do what brings him or her happiness and to avoid suffering. Related to the concept of happiness is one's own value system. Consider this example. We have two patients. The first one values travel very much. He enjoys going to different places. One day, he can no longer travel because of the illness. He may say that since I can't travel and that's what I want to do most, I don't want to lie in bed for another 10 years. Just let me go peacefully. And he refuses treatment for some serious illness. There's another patient who's a writer. He values the ability to write very much. So he said that, "As long as I can write, keep me alive. I don't mind lying in bed." Now, both are reasonable and we have to respect their values and decisions. The third reason to respect patient autonomy is to avoid tyranny. I hope that this is no longer an issue in the future, but in the past, we had governments trying to take away patients' own right to make decisions. We have to build a culture of respecting autonomy to prevent this from happening in the future. Finally, the last reason to respect patient autonomy is to avoid conflict of interest. Many patients will say, "Hey doc, you know more. You know what's best for me and I'll let you decide." This is not a good way to do things because doctors all have limitations. Sometimes there's a financial conflict because of the payment system. The more a doctor does, the more he gets paid, so there's potentially financial conflict of interest. Another issue is that doctors all have limitations and bias due to their training. If you have cancer, you talk to a surgeon, the surgeon may recommend surgery. You talk to a radiologist, he may recommend radiation therapy. You talk to an oncologist, he may recommend chemo. All of them are correct, but they're limited by their training and experience. So ultimately, the patient has to decide what is best for him or her. When we say that patients have a right to make their own decisions, that doesn't mean that they can request or ask for anything or everything. First of all, only competent adults have a fundamental right to make their own decisions. A minor or someone who's mentally incompetent does not have this as a fundamental right. They may still have some rights, but not a fundamental right. More importantly, patients have a right to refuse service, but they do not have a right to demand service. For example, a cancer patient, he has a fundamental right to refuse surgery. But if a surgeon says that, "I won't operate on you because the chance of success is only 5%. There is a 95% chance that you'll die on the examination table, and I don't want to take that chance." The patient cannot demand the surgeon to operate on him even though he wants to take the 5% chance. Another related idea is the concept of resource. A patient does not have a right to demand certain resources. For example, a patient may need a liver transplant and he wants a liver transplant. However, there's no guarantee that he can get one. If a liver is not available, it is not available. He can refuse a liver transplant, but he cannot demand one. Another important concept in patient autonomy is that you cannot put others at an increased risk. This is mainly applicable in infectious disease conditions. For example, if you have TB and you refuse treatment, your cough can spread the germs to others, and the government can lock you up to protect others. Mandatory vaccination is the same concept. If you refuse vaccination, you can put other students at risk, so the government can prevent you from going to school. During a pandemic, quarantine and mandatory mask requirement are similar ideas. Finally, patient autonomy cannot violate local laws. For example, in the United States, physician-assisted suicide is legal in certain states. However, if a patient tells a doctor, "I want you to give me an injection to kill me," this is illegal. This is beyond physician-assisted suicide. And even though the patient has an autonomy to his or her own life, he cannot ask a doctor to do this because this is just illegal. Let's come back and talk about healthcare directives. I mentioned earlier that there are actually several legal documents involved. The first one is called a living will. Why is it called a living will? We may be familiar with the concept of a will. Well, a will is effective only after the patient died. A living will, on the other hand, is effective when the patient is still alive. That's why it's called a living will. The second document is called a durable power of attorney. In this document, the patient appoints someone to be his or her representative. It's called durable because in a usual power of attorney, when the one making the power of attorney becomes incapacitated, it automatically expires. But when we make this document a durable power of attorney, it remains effective even when the person making the document becomes incapacitated. His representative or her representative is called the attorney in fact. The third document is called a Do Not Resuscitate or Dnr Order. This is a very specific document. It's only relevant when the patient is at a critical stage. We'll talk about this a little bit later. The fourth document is unique to the United States as far as I know. It's called a Physician Orders for Life-Sustaining Treatment, or in short, the POST form. What's the difference between POST and a living will? And why do we need both documents? We'll talk about that soon. There are some common elements to these four types of documents. First of all, they are effective only when the patient can no longer express the decision. Sometimes patients may be afraid that once they sign a document, they cannot override it. That's not true. As long as the patient is awake, he can always override any of the documents. The second element is that patients have a right to change it at any time. Just like a will, if the patient's wish changes, he or she can change it at any time, and the most recent one is the only effective document. Finally, all documents are ineffective when the patient is in surgery. When the patient is getting surgery, the only option is to do everything possible to save the life of the patient. Now let us talk about the four different kinds of documents. A living will is for a patient to write down his or her wishes. He or she can write down anything, can wish for anything. However, others need not follow his or her demands unless the patient has a contractual relationship with an executor. In this case, the executor is bound as the patient's agent to do what he or she is hired to do. But this is basically an employment contract. Now, in most jurisdictions, a living will has only persuasive power. It is not a legally binding document. But in reality, in practice, most doctors and hospitals will try their best to honor the patient's wishes. There's no reason to pick a fight. If the patient wants something that's legal and doable, why not just do it? I'm sure that someone will ask this question. If the living will is not a binding document, why do we have to do one? I think that the reason for doing a living will is that we can use it as a tool for us to write down our wishes and to express our value preferences, so that the attorney in fact that we appoint can know what to do when the time comes. Now let us move on to the durable power of attorney. As the name said, this document allows you to appoint someone as your attorney in fact to represent you when you cannot make decisions. You can appoint one or multiple persons as your representative. However, if you're appointing more than one, then you should make it an odd number in case they cannot reach a consensus. they can at least vote and without getting into a tie. One recommendation is that you do not appoint just one person, because it may be too stressful for someone to try to make a life and death decision for you. So if you appoint several, then they can at least discuss among themselves, and it is less stressful for one person to make that kind of critical decision. Yet if you appoint more than one, then the ideal number would be 3. If you go to 5 or 7, the group becomes too big and unmanageable. You can also appoint alternatives. They can act when your first choice cannot act or is not available. Now, for minors and mentally incompetent patients, they cannot appoint an attorney. In fact, the parents or legal guardians are their next of kin. The next of kin has certain authorities similar to an attorney in fact, but a little bit different. We'll talk about that in the next slide. When a patient does not have a formal attorney in fact, the hospital or doctor will usually try to find the next of kin to serve as representative for the patient. Now, this is not formally required, but hospitals and doctors will often try to do this. When we have more than one relatives or next of kin, who makes the decision? Different states have different rules. In California, the order is like this: spouse, and then children, and then parents, siblings, grandchildren, grandparents, and nephews and nieces, and so on. One big difference is that the next of kin has less authority than attorney in fact. It is very difficult to overrule the decision of an attorney in fact. You have to prove that either the attorney in fact is not acting at the best interest of the patient, or is himself or herself mentally incompetent. That's very, very difficult to do. But the decision of the next of kin can be can be challenged. One classic example is the Jehovah's Witnesses. They're a group that oppose blood transfusion. They think that it is very unethical to get a blood transfusion, and if they die, they'll go to hell. Therefore, they usually wear bracelets saying that do not transfuse me because I'm a Jehovah's Witness. Now, if they're an adult, doctors will respect their wishes. However, if we have children of a Jehovah's Witness coming into the hospital and requiring a blood transfusion, we'll argue that the child is too young to make his own decision on religious matter. We don't know whether he'll become a Jehovah's Witness or not. So we will try to override the wish of the parents. We'll go to court to find a judge that will sign an order allowing us to transfuse. If an adult patient appoints a Jehovah's Witness as his or her attorney in fact, and the attorney in fact refuses blood transfusion, usually we won't do anything because we'll assume that the patient is mentally competent to make this decision, and the attorney in fact truly represents the patient. The third document is the post. This is a very important legal document in the US. It is needed because healthcare professionals do not have to follow the patient's living will. Now, that itself makes sense. That's because a patient can wish for anything in the living will. Some of those wishes may not be doable or may not be legal. Therefore, the patient cannot require a healthcare professional to follow his or her will. But when healthcare professionals do not need to follow a patient's living will, that creates another set of problems. For example, a patient may wish not to be resuscitated in case his heart stops beating, but there's no guarantee that healthcare professionals around him will follow his wish. To get around the limitation, the US introduces the concept of post. Post is a set of orders prepared by the patient's doctor. Doctors have legal rights to issue orders for other healthcare professionals to follow. So, the doctor should discuss the patient's wishes with him or her, documents the discussion in the chart, writes the orders for other healthcare professionals to follow. Like the living will, the post can be changed at any time. For a post to be effective, it must be available at any time for other healthcare professionals to access. In the past, this created some difficulty. Now, I have one recommendation. Scan in the document, put it in Google Drive or Apple iCloud, then it will be available on the phone at all times. Besides the legal authority, is there any difference between post and living will? The post is used only to address the very last stage of a patient's life, such as CPRs, ventilations, artificial nutrition, and so on. The living will can address any wish of the patient. For example, the patient can use the living will to specify whether he'll get chemo in case he has cancer, or what medication he wants to take, what medication that he does not want to take, etc. So living will covers a lot more scenarios than post. In the US, when preparing for the post and the living will, different states have different signature, witness, and notarization requirements. You need to check with your state to find out what is the proper way to prepare these documents. When you move from one state to another, the living will usually will still be valid because it is not legally binding anyway. However, the post may or may not be valid in another state. It is best to prepare a new post form when you move to another state. The last document is the Do Not Resuscitate or Dnr Order. It is applicable only when the patient's heart stops beating. Like post, it must be signed by a doctor. It specifies whether to perform CPR or defibrillation on a patient when the heart is not working. It is only used in the hospital and when the patient is at the very critical moment of life. So we have discussed the 4 kinds of healthcare directives. The question then becomes, which ones do I need? To answer the question, we need to understand the limitation of post and living will. Both are written documents, and as a written document, they have certain limitations. The major problem with post and living will is that they cannot respond to rapidly changing clinical and family condition, and therefore may put the patient in a situation that he or she cannot foresee when preparing the living will or post. I often use this example to illustrate the point. It is very common for patients to say that I don't want to be put on a respirator. I don't want to die like that. When the time comes, just let me go peacefully. That is a reasonable request and a very common one. However, if the patient writes down, "Do not put me on a respirator," then it sort of binds the doctor's hands. Let's say the patient suffered an injury, an accident, and if he or she is put on a respirator for a few days, there's a good chance that he or she can recover. If the patient writes down not to put it on a respirator, then the patient may die prematurely. Another scenario is more culturally related. Very often, families want to get together before the patient dies. Nowadays, it's very common for a family to have members all over the world. If you need to fly from the east coast of the United States to the west coast, you need to buy a ticket, get to the airport, get on a plane, get off the plane, and then get to the hospital. That easily can take you 8 to 10 hours, maybe even more. So if you want the patient to last until all family members have come together, a respirator may be the only viable option for just a few hours or 1 or 2 days. Those scenarios cannot be easily written down as rules or wishes in a living will or post. Therefore, my recommendation is that in addition to having post and living will, you also have an attorney-in-fact who can make hour to hour decisions reflecting the current clinical situation and the family situation. Finally, let me tell you what are my recommendations. I recommend that everyone should have a durable power of attorney, a post, and a living will. The DNR is just a subset of the post, so it's not necessary to prepare a separate one. Also, the DNR may or may not be what you want. The post and living will should have no conflict. They should both reflect the same wishes that you have. For example, if you don't want to be put on a respirator, then both documents should say the same. You should have an attorney-in-fact that knows your wishes and can make day-to-day decisions for you. Most importantly, you need to discuss these issues with your family members when you're healthy. Don't wait till the last moment that you're very sick. In this video, I discussed the legal documents. I have not discussed the life-sustaining technologies in detail. In the next video, I'll try to explain those technologies to you. Thank you for watching, and if you find the information in this video useful, please share it with your friends and relatives. Bye bye.